Sometimes the biggest fights start over the smallest things. Believe it or not, this is a story about how a simple backyard swing set for 3 kids ended up sparking a massive, year-long legal battle. We're going to dive into a real-life fight that tested the absolute limits of a homeowners association's power. So here's the big question. Can your HOA really stop you from building a swing set for your kids? You'd think the answer would be simple, right? Well, for a homeowner named Scott Ketchum, it turned into a fight that went all the way to a judge. His story is just a fascinating look at property rights, community rules, and honestly, the power of reading the fine print. All right, so let's set the scene. It's April 2005. The Ketchum family, with their 3 young kids, moves into a new house in Arizona's San Marcos Manor community. It's a planned community, which means it's governed by a homeowners association or an HOA. And that, right there, is where the trouble starts. Now, for anyone who hasn't had the pleasure of dealing with an HOA, let's break it down. When you buy a house in a community like this, you're basically signing a contract. You agree to follow a whole set of rules, often called CC&Rs, that can control everything from the color you paint your front door to, what you can put in your own backyard. So later that year, the Ketchums are all settled in, and they do what pretty much any family with kids would do. They put up a play set in the backyard. Mr. Ketchum even said he'd called the community manager beforehand and thought he did everything right. He figured all he needed was a thumbs up from his neighbors. But what started as a totally normal backyard project quickly turned into a major dispute. The second the HOA caught wind of the new structure, that friendly neighborhood vibe just vanished, and things started to get serious fast. And this right here, this is the heart of the problem, physically speaking. The standard backyard wall in the community is 6 feet high, but the Ketchum's new playset, it was a whopping 13.5 feet tall. It was more than double the height of the wall, so it was pretty easy to see from outside the yard. So then we get to December 28th, 2005. The Ketchums get their first official notice. It's called a friendly reminder, but it basically says the playset breaks the rules because it's visible over the fence and wasn't approved. And that, my friends, was the first shot fired in what would become a year-long conflict. Okay, and this is where the story gets really interesting. Because at the end of the day, this whole fight wasn't just about how tall a swing set was. It was about a huge disagreement over what the HOA's own rulebook actually said. The HOA side of things was pretty simple, at least to them. They said, hey, we've got this standard, an unwritten one, but a standard nonetheless. Nothing in your yard can be taller than the 6-foot wall. They'd said no to stuff like this before, and they weren't about to start saying yes now. But Mr. Ketchum wasn't having it. He actually went and read the rule book, the CC&Rs, and all the guidelines. And he argued, hey, show me where it says you can't have tall structures. It doesn't. He pointed out that the rules just said that anything taller than the wall needed approval. His point was, you can't deny something based on a rule that you just made up. And look at this. This slide lays it all out perfectly. On the one hand, you've got the actual written rule. Improvements exceeding the wall height require committee approval. That implies there's a process, a review. But on the other hand, you have the HOA's decision. Denied. Period. They basically turned a review process into a total ban. So what do you think the HOA did when faced with this pretty solid argument? Did they reconsider? Did they maybe check their own rules? Nope. They just doubled down, moving from sending letters to hitting the family with serious financial penalties. It started on June 14th with a little $25 fine. Okay, but then just 2 weeks later, bam, it's $100. Through July, 4 more $100 fines get slapped on. The penalties just kept stacking up week after week. It was a clear strategy to just bury the Ketchums in fines until they gave up. And by the time this all got to a hearing, the number was just staggering. The HOA was demanding a total of over $4,800 from the Ketchum family. You're talking more than $2,000 in fines, plus another $2,600 in attorney's fees. All of this for a kid's playset. All right, so the fines are piling up, there's no end in sight, and Mr. Ketchum decides he's had enough. He files a formal petition which takes this whole mess out of the neighborhood and puts it into a courtroom. The big showdown happened on January 11th, 2007, in front of an administrative law judge. So, in court, it all comes down to this. Mr. Ketchum says, you're enforcing a ghost rule, one that doesn't actually exist in writing. He even had an expert witness who said the HOA's refusal to even look at the application was arbitrary and capricious. The HOA just fired back that they could deny whatever they wanted and that they were just being consistent. So the judge has heard both sides. The HOA's claim of an unwritten tradition versus Mr. Ketchum's cold, hard text from the rulebook. And after looking at everything, the judge decided that the HOA's refusal to even think about it, to use any discretion at all, was arbitrary and capricious. Now, that's a fancy legal term, but what it really means is that the decision was made for no good reason. It was just random, based on a whim. The judge basically said that since the rules required the HOA to review these kinds of applications, their blanket refusal to do so, their insistence on this non-existent automatic ban, was totally improper. And the final ruling? It was a total knockout for the Ketchum family. Check it out. First, the judge told the HOA, "You're going to go back and fairly review this application based on the rules you actually wrote." Second, every single one of those fines, gone, thrown out completely. And third, the HOA had to pay Mr. Ketchum back for his filing fee. A clean sweep. So what's the big lesson here for all of us? It's simple, really. An HOA has power, for sure, but it's not a dictatorship. It can't just invent rules on the fly. Its power comes directly from and is limited by the words written in its own rulebook. If it's not in the text, it's not a real rule. And that really leaves us with a huge question, especially if you live in one of these communities. It forces you to ask, is your HOA a reasonable group protecting property values by sticking to the rules, or is it an organization that's just making things up as it goes along? The difference, as the Ketchum family found out, is all in the fine print.